Plea bargaining is used to resolve criminal cases without having to go to trial. A plea bargain is an agreement between the prosecutor and the defendant, where the defendant agrees to plead guilty to a charge or charges in exchange for a more lenient sentence. There are pros and cons to plea bargaining. One of the pros of plea bargaining is that it allows the defendant to avoid the maximum sentence for her charges. Additionally, plea bargains eliminate the uncertainty that comes with trial. Not only is plea bargaining beneficial to the defendant, but is also beneficial for the prosecution. Plea bargaining prevents congestion within the courts, allowing prosecutors to handle more cases. As you can see, the defendant and the prosecution benefit from the plea bargaining process. Not surprisingly, 95% of cases are pleaded out. However, there are cons to plea bargaining. One of the most obvious cons to plea bargaining is that factually innocent people may be pressured into accepting a plea offer. If a defendant is factually innocent, but the prosecution has an overwhelmingly convincing case against the defendant, then the defendant may be forced by circumstance into pleading guilty to a crime he or she did not commit. Another con of plea bargaining is that a defendant may end up with a better outcome in court than with a plea bargain. When a defendant is offered a plea deal, she must take into consideration the pros and cons of accepting the plea offer. So what kind of offers are made in plea deals? Well, there are 4 types: charge bargaining, sentence charging, fact bargaining, and count bargaining. Charge bargaining is where the prosecutor offers a reduction or dropping of a charge to a lesser one in exchange for a guilty plea or no contest. This tends to be the most common deal made by a prosecutor. Sentence charging is where the defendant makes a deal with the prosecutor to recommend specific sentences, such as probation and community service, instead of jail time. Fact bargaining is where the prosecutor agrees to omit certain facts or evidence from the charges on the condition that the defendant enters a specific plea. This is the rarest of pleas and is the most difficult to get a court to agree to. Lastly is count bargaining. This type of deal involves the defendant pleading guilty to a specific charge to get a more serious charge dropped. It is important to note that a judge must agree to the terms of all plea offers. There are many things taken into consideration when the prosecution and defense are negotiating a plea offer. The top 3 factors that influence what the outcome of a plea offer will be are the seriousness of the crime, the quality of evidence, and prior convictions. Prior convictions are important in determining plea bargains. When there are prior convictions, especially if it is the same offense, the prosecutor has more leverage. The prosecutor is less likely to give the defendant a favorable deal. For example, in Colorado, most DUIs are dropped to a DWAI, but if it is a 3rd drunk driving offense, then the plea offer may not include a reduction to a lesser charge, and may also involve a short stay in jail. The quality of evidence is important both for the prosecution and the defense when considering a plea offer. If the evidence is solid and will most likely convince a jury to convict, then the prosecution is unlikely to offer a deal that the defense would like. Conversely, if the evidence against the defendant is weak and would likely not convince a jury to convict, the prosecution will usually offer a deal very favorable to the defense. The seriousness of the original offense plays an important role as well. The prosecution is more likely to offer plea bargains to less serious offenses, such as drug possession. However, the more violent crimes, like murder and rape, are often not offered plea bargains. Now let's take what we have learned and apply it to a real case. Our case concerns a 21-year-old man named Sam. He is an engineering student at a local university, and is going to graduate near the top of his class. He's never been in trouble with the law and spends his free time as a tutor, for which he doesn't get paid. When Sam was arrested, marijuana legalization was on the docket. Anyways, one night he was driving eastbound on Elizabeth Street. He is subsequently pulled over by a police officer for not having his headlights on. The officer approaches Sam's car and smells alcohol emanating from within Sam's car. The officer then asks Sam if he had been drinking. Sam answers yes, but that he doesn't remember how many drinks he had. The officer asks Sam to do roadside maneuvers, which are field sobriety tests, but Sam declined. The officer then arrests Sam for suspicion of a DUI. Incident to arrest, the officer legally performs a search of Sam's car and discovers less than a gram of marijuana. To put this into perspective, if you reach into your pocket and pull out a nickel, that's 1 gram. Sam had less than that. So not only is Sam arrested for a DUI, but also possession of marijuana. Under implied consent laws, Sam must either give a blood sample or do an intoxilizer, which is a fancy breathalyzer they have at the station. Sam chooses to do blood. After this incident, Sam retains my bosses as his attorneys. A couple weeks later, the blood results come back. His BAC, or blood alcohol content, at the time of the incident was 0.081. If his BAC was between 0.05 and 0.079, that would be a DWAI, a lesser offense. So you have the basic facts of the case. Now here's my question. If you were part of Sam's defense, would you urge Sam to seek a plea offer or take it to trial? Pause the video here so you can think about it. If you chose to go through with a plea offer, you did right. From Sam, you have not only an admission of guilt, but also physical evidence that he was under the influence and physical evidence of marijuana in his possession. He would have no chance at trial. The question here is, now that you were going through with a plea offer, how would you approach the prosecutor? What would you say? And what results do you think you would achieve? Take into account all the information that has been provided. Pause the video here and give yourself some time to think about it. Well, I'll let you know how I approached the prosecutor. Also, contrary to popular belief, interaction between the defense and prosecution is not usually adversarial. In fact, she was showing me pictures of her puppies on her cell phone before we even started talking. But that's neither here nor there. This was my opening argument. I said, Sam is an engineering student, smart kid, about to graduate near the top of his class, and never has been in trouble with the law before. He made a bad judgment call that night, and he felt bad about it. So much so, he didn't even hesitate to tell the officer. Sam is not some wild bandingo. He is a genuinely good kid. As for his BAC, he was barely over 0.079. Also, as for the possession charge, I think you and me know marijuana is about to be legalized. And if I ever got a possession charge for a minuscule amount of weed on my record, only to find out it gets legalized less than a year later, I don't know about you, but I'd be pretty upset to say the least. This kid needs a light spanking, nothing harsh. So what I'm requesting from you is that you lower the DUI to a DWAI and drop the possession charge. What are your thoughts? So that's what I said to the lady. What results do you think I got? Pause the video here and think about it. So the results I got were exactly what I asked for. That is, reducing the DUI to a DWAI and dropping of the possession charge. I guess what this case illustrates is that there are many factors taken into consideration when negotiating plea bargains. Everything from the rapport that the defense counsel has with the prosecution to the character of the defendant. Also, there is no textbook on how to negotiate plea offers. But whenever a plea offer is made, the defendant needs to make an informed decision about how he or she will take it. They have to weigh the pros and cons. I'd like to give a special thanks to the following people for their contribution and research who made this video possible. I'd like to say their names, but I'm afraid I'd butcher them, so I posted them here. Here are references. And again, thank you for listening. Have a wonderful day.